Damn. Oh, shit.
Walk away! She's spit in my face! You saw that! I got you on camera! I got you on camera!
Oh my God! Stop, everybody! Stop!
Well, something's going on in there.
It's Amazon. It's my Amazon wish list.
A man and woman were arguing loudly on the street, their voices echoing as passersby glanced over.
Oh my God! You killed me!
I did not kill you. You're fine.
Oh my God!
You sprayed me with.
A man was arguing fiercely with the store clerk, his voice rising with frustration as other customers watched the heated exchange unfold.
Food, hurry up! I'm waiting. I shouldn't be. Call the police. Hurry up with my food, or I'm gonna get you a new wig. Give me my money back quickly. It was on a cord, bum. Hurry up.
A fight broke out at the airport between two passengers, causing chaos as security rushed in to separate them and restore order amidst the panic crowd. A violent altercation erupted between two men on the street, drawing a crowd as they exchanged blows before the police arrived to break it up. A woman and a man had a heated argument in the store, their voices rising as they disagreed over a product. Other shoppers watched uncomfortably as tensions escalated.
Give me my bag! Give me my bag! What are you doing? This person's taking my bag. That's my property. Hey, that's what's the problem.
There you go.
You know, you didn't do that on purpose. No, sir.
63, did you get my last transmission?
Tenderizing my chicken. I'll come by
Stop by the house. You know where I be.
I'm glad that you are somebody I know.
Tell my camera again how you're a police officer.
Will you answer my question? I've answered. What are your probation officers considered to be?
I have no idea. We're not in Alabama. I guess when a police officer gets here, we'll determine a whole bunch of stuff.
Welcome back to Cops America, your go-to channel for all things law enforcement. Today we delve into Karen gets knocked out cold after power hit. Don't forget to subscribe to Cops America for more eye-opening content like this. On February 26, 2022, Michael Skurlock, 65, was struck by a pickup truck in Dickinson, Texas, as he was riding his bike. Officer Michael Kinsley of the Dickinson Police Department rushed to the scene, and Officer Kinsley's body camera and Officer Kevin Chance's body camera both recorded the subsequent exchange.
63, show me out on that auto pit. You all right?
We had a little get together. He's being stubborn about getting checked out, but he said he's all right. So we're just.
You all right?
I told him I want to take
No,
him down.
I ain't all right. I need about $1 million, and then I'll be all right.
Well, you ain't getting that, so.
Yeah.
Well,
He's always
you
up
go
and down my
ahead and
street,
get that.
so I want to get you down.
I got that, I can put that mother son of a bitch.
Yeah.
All right.
Well, so what do you want to do?
I'm gonna put this thing on and put that shit in.
63, he's not injured, no ambulance needed. Can you run Michael Spurlock?
No. I think I'm on the roof. Flip that cover over. I don't think you're going at it right. There you go.
Yeah, I got the tools at the house. You know where I live.
You didn't do that on purpose.
No, sir.
63, did you get my last transmission?
You're right. I'll come by you.
Stop by the house. You know where I be.
I'm glad that you are somebody I know.
Hey, hold on. Don't go anywhere yet.
What do you mean don't go anywhere yet?
Exactly what the fuck I mean.
said-
Don't go anywhere yet.
Hey, what the is it have I done?
I was.
What?
What happened?
He hit me
I was
accidentally.
right
EMS
down
is
the
not
driveway,
needed.
I was looking that way to go, and I was starting to ease out. And the next time I see a flash in front of him, he goes.
I was
you know,
worrying about
bump
flat. Now,
Yeah.
I ain't worried about flat. Look at that fucking wheel.
Wee! What were you driving?
I got to fix a flat in that son of a bitch. And it ain't supposed to fix the bicycle tire. It adheres to the tire. And that son of a bitch is leaking down. Boom, bang.
Mr. Scurlock was detained by Officer Kinsley, prompting a concerning turn of events. According to witnesses and body camera footage, tensions escalated when Mr. Scurlock attempted to retrieve his belongings, resulting in Officer Kinsley forcefully restraining him. This led to Mr. Scurlock falling to the ground, apparently losing consciousness. While the exact nature of the force used remains unclear, bystander alleged that Officer Kinsley flipped Mr. Scurlock and slammed him headfirst into the curb. Officer Kinsley, however, maintains that he employed a tactical takedown maneuver involving wrapping his arms around Mr. Scurlock's legs. In the landmark 1989 case Graham v. Connor, the U.S. Supreme Court outlined crucial considerations for determining if the use of force by law enforcement is constitutionally excessive. These considerations, commonly referred to as the Graham factors, serve as guiding principles for courts. They include the seriousness of the alleged offense, whether the suspect poses an immediate threat to the safety of officers or others, and whether the suspect is actively resisting arrest or attempting to flee.
All right, am I through?
No.
What have I got to do?
You gotta wait here
Tell me.
till we finish our investigation.
Investigation? There ain't
Matter of fact, have a seat. Seat on the curb.
Matter of fact, I was out there laying.
Have a seat on the curb. Have a seat
That's
on the
what you're
curb.
supposed to do.
Have a seat on the curb.
She hit me. I wasn't. I thought he saw me.
Hey, have a seat on the curb.
I'm
Or
gonna
you
look
come-
for my stuff, young man.
All right, turn around. For
Come on now, wait a minute.
Hey,
What are you doing?
hey,
Hey,
you're gonna have a seat. Put your hands behind your back.
We need him now.
63, go ahead, roll an ambulance.
Analyzing the situation through the lens of the Graham factors, it's evident that Mr. Scurlock, although initially uncooperative with Officer Kinsley's instructions, was not engaged in criminal activity nor posed a threat. His non-compliance, potentially justifying a misdemeanor charge for interference with a public servant, should be understood in the context of his lack of arrest at the time. It's crucial to note that under U.S. criminal law, an individual cannot resist arrest if they haven't been formally placed under arrest. Thus, Mr. Scurlock's actions, while technically non-compliant, do not constitute evasion or resistance. The Fifth Circuit Court of Appeals overseeing Texas clarified the criteria for establishing excessive force claims. Referring to the 2000 case of Goodson v. City of Corpus Christi, the court emphasized that plaintiffs must demonstrate three key elements: an injury directly resulting from force clearly excessive to the need, and the use of objectively unreasonable force. And this underscores the high threshold for proving such claims within the legal framework. Furthermore, a pertinent 2014 case, Bakey v. City of Galveston, addressed the issue of qualified immunity concerning an officer's use of force. The officer argued that a citizen's non-compliance with police orders could justify force. However, the U.S. District Court for the Southern District of Texas rejected this notion. It clarified that failure to obey orders is inherent within the evaluation of excessive force, rather than an independent justification. This ruling reaffirms the principles outlined in the Graham framework, which governs the assessment of police use of force incidents.
You got a car, don't you?
A car for what?
To get me home.
No, I don't have a car to get you home with.
Well,
Mr. Skurlock, you have the right to remain silent. You have the right to a lawyer. You have the right to have a lawyer present at any interview at the place you're
what for?
You have the right to terminate any interview at any time. You don't have to make a statement, but I must warn you, any statement you make can or will be used against you. Application, I'm going to set a bond of $581. Can you make bond, sir? I take that as a no.
Yeah.
What are you going to do? What do we do?
Oh, how am I here?
You got arrested for public intoxication yesterday.
I got beat on yesterday.
Having signed that, fill that out. If it has any information, we'll go from there. No, you're getting out.
You getting out. Sign right here for me.
Oh.
Give me your name on it the best you can.
Man, I can't see.
Huh?
I can't see. Yeah.
Right here. Sign your name the best you can.
Okay.
Okay. Just sit right there on the bench for me.
I think this one got, I think this is.
God, mighty.
That got. Okay.
Oh, man.
Okay, hey, you're gonna have to be quiet.
I see that.
You have to be quiet right there.
Man.
Destiny, come on.
I can't come on.
The judge is out here.
No.
Sit him right there.
Is he out?
Huh?
Is he out? You know his name?
Michael Skurlock, I believe.
In the Bakey case, the court assessed the citizen's alleged refusal to obey orders within the context of the severity of the crime, a principle outlined in the Graham v. The court emphasized that the act of refusing to leave an area amounted, at most, to interference with a public servant. It stated that, according to established legal standards, no reasonable officer would find it justifiable to use significant force, such as a taser, for such a minor offense, especially without attempting less severe measures first. Though Officer Kinsley didn't use a taser, his use of force on Mr. Skurlock, resulting in loss of consciousness without prior attempts at less forceful intervention, raises concerns of excessive force. In the midst of awaiting EM assistance, Officer Kinsley and Officer Chance engage in a discussion regarding the potential intoxication of Mr. Skurlock. Despite the absence of evident signs of inebriation in the body camera footage, Officer Kinsley, following consultation with a superior, proceeded to apprehend Mr. Skurlock on charges of public intoxication. It's noteworthy that no blood alcohol concentration test was administered. In justifying the arrest, Officer Kinsley refers to a legal concept known as the public place doctrine. According to this doctrine, any area accessible to the general public or a significant portion of it is considered a public place. This includes not only streets and highways, but also common areas of various establishments such as schools, hospitals, apartment complexes, office buildings, transportation hubs, and shops. By invoking this doctrine, Officer Kinsley implies that Mr. Scurlock was likely in a public place when he was arrested. In the case under scrutiny, the central question revolves around whether the officers possessed sufficient grounds, legally termed probable cause, to suspect Mr. Scurlock of intoxication. And the Court of Criminal Appeals of Texas deliberated on this matter, focusing on the evidence available to the officers at the time of the encounter. Their contention was that the sole basis for suspicion was Mr. Scurlock's purported erratic behavior earlier in the day, and the presence of a container potentially holding alcohol. However, a critical analysis of the situation reveals gaps in this reasoning. Body camera footage failed to depict any overt signs of intoxication in Mr. Scurlock, such as slurred speech, impaired balance, or bloodshot eyes. Additionally, there was no indication that the officers detected the odor of alcohol on Mr. Scurlock or his vicinity until after physical confrontation ensued. Mr. Scurlock, requiring medical assistance, was not tended to by Officer Kinsley. Drawing on the 1983 case of Ruffey, Massachusetts General Hospital, the Supreme Court affirmed that municipalities have a constitutional obligation to provide medical care to those injured by police during their duties. This raises concerns regarding Officer Kinsley's actions, potentially constituting a breach of duty. Moreover, the Supreme Court ruled in Ruff that deliberate indifference to the serious medical needs of individuals violates the Eighth Amendment's prohibition on cruel and unusual punishment. Scurlock's evident symptoms suggest a serious medical condition, highlighting a possible case of deliberate indifference by jail officials. By failing to address Mr. Scurlock's medical needs promptly, they may have violated constitutional rights. Following Mr. Scurlock's release, he tragically passed away due to complications stemming from a brain hemorrhage caused by Officer Kinsley. An internal affairs review by former Dickinson Lieutenant Frank Price initially found no wrongdoing by Officer Kinsley. However, subsequent investigations shed new light. 7 months later, upon a whistleblower's revelation, Mr. Poirot was appointed to delve deeper. His inquiry revealed crucial medical oversights by Lieutenant Price and deliberate misrepresentations by then Police Chief Ronald Morales. The Galveston County District Attorney's Office Public Integrity Division scrutinized the findings. Subsequently, on February 22, 2024, Officer Kinsley was indicted by a grand jury for allegedly abusing an elderly person, a third-degree felony, and official oppression, classified as a class of misdemeanor under relevant U.S. and criminal law.
I don't think you're going at it right. Where you go?
Yeah, I got the tools at the house. You know where I live.
You didn't do that on purpose.
No, sir.
63, did you get my last transmission?
Right. I'll come by
Stop by the house. You know where I be.
I'm glad that you are somebody I know.
Seat on the curb.
Matter of fact, I was out there laying.
Have a seat on the curb. Have a seat on the curb.
That's what you're supposed to do.
Have a seat on the curb.
She hit me. I thought he saw me.
Hey, have a seat on the curb.
I'm gonna look for my stuff, young man.
All right, turn around.
Come on now, wait a minute.
Hey.
What are you doing?
Hey, you're gonna have a seat. Put your hands behind your back. I don't know. I tried to get him to sit down because it looked like he was going to walk away. He wouldn't do it, so now I told him, put your hands behind your back and start resisting.
In summary, Officer Kinsley's actions are graded as F because they show an extreme degree of apathy and involve the use of excessive and unjustified force against Mr. Scurlock. Additionally, the police receive a failing grade for their apparent attempt to conceal the incident and their refusal to admit Officer Kinsley's misbehavior. The horrific nature of this interaction speaks for itself, and the Dickinson police and jail staff engaged in this incident would undoubtedly receive a grade lower than an F. On August 4th, 2021, an incident unfolded in Alabama involving William Barnwell and Harold Mashburn, a local resident and a probation and parole officer from North Carolina, respectively. Barnwell, frustrated by Mashburn's slow driving in the left lane, attempted to pass him on the right. Mashburn, however, reacted by displaying his badge and signaling for Barnwell to pull over.
Sir, you can film me all day long. If you're a police officer, you should have a body camera. Because you're not a police officer. It says right there you're a probation officer. I'm not on probation. I've never been in trouble for anything.
In the state of Alabama,
Tell my camera again how you're a police officer.
will you answer my question? I've answered. What are your probation officers considered to be?
I have no idea. We're not in Alabama. I guess when a police officer gets here, we'll determine a whole bunch of stuff.
Okay.
How often do you pull someone over?
How often? I pull people over.
How often do you drive in the left lane for 5 miles going 48 miles an hour? So how fast were you going?
I was doing 55.
And what happened?
You come flying up on
No,
my back
when I
end?
passed you, I was going 48 miles an hour.
doing it
But if your
aggressive
car here that's not a police car had the radar in it, you would know how fast I was going. I'm sure you will be. I guess when your real police officer gets here, I'm sure I'm going to get some tickets.
All right. Well, you just stay it tight.
What's your name? Would you like to identify yourself?
Have you going to give me your driver's license?
You're not a police officer.
Okay.
You're refusing to identify yourself even though you pulled me over.
Sit tight.
Am I being detained? Am I being detained, sir? Because I've got to go home. Are you detaining me? Am I being detained? Hey, I'm going to step out. Because you're... Am I being detained because I need to be on my way? Is this a lawful stop? Am I being detained? Are you detaining me? Are you detaining me? Is that hard to understand? Because you know this is not legal. This is not legal.
Following the signal, Barnwell complied with Mashburn's instructions to pull over. However, a disagreement arose as Barnwell questioned Mashburn's authority as a probation and parole officer. This situation highlights the varying roles and powers of probation officers across different states in the U.S. While some jurisdictions empower probation officers with law enforcement capabilities akin to regular police officers, others view them primarily as court officials with a focus on rehabilitation and social work. In North Carolina, probation officers operate within specific legal boundaries, as outlined by Section 15 to 205 of the state's general statutes. Their authority is limited to cases involving individuals under probation supervision. While they possess powers to investigate, arrest, and execute legal processes within this scope, their jurisdiction does not extend to general law enforcement duties concerning the public. And a recent incident involving probation officer Mashburn highlights the importance of understanding these boundaries. Mashburn's actions, such as stopping Mr. Barnwell for aggressive driving, appears to exceed the permissible duties of a probation officer in North Carolina. It's crucial to note that under the Fourth Amendment of the U.S. Constitution, individuals are considered seized if law enforcement intentionally restricts their freedom through force or a show of power.
Hey, I'm going to leave now because you won't tell me if I'm being detained or not. Am I being detained? Say it. Sir, am I being detained? Will you say those words? Am I free to leave? Am I free to leave? So I am being detained. Why don't you answer that? You're not talking to anybody now. How long can you keep me on the side of the road as a prisoner? Am I free to leave right now? Am I being detained? Why don't you say that? Am I being detained? Yes, I need to go home because we're on vacation. Am I free to leave? Am I being detained? Why won't you say those words? You know, you're well versed in the law. You are a law officer. You told me that. Am I being detained? It's a yes or no question. So am I being detained? Why can't you say that? You're mincing words. I will. Am I being detained? I'll get back in my car. What's so hard to answer? That's fine. That's fine. You're why can't you answer my, you know you're in the wrong. You know you're in the wrong. That's why you're sitting there with that fake smirk. Am I free to go? Am I being detained? Those are yes or no questions. For how long? I'm gonna go home now. I'm going home now. Am I free to go? Am I being detained? So now he's gonna get my tag. How long does a Terry stop last, sir? So what am I being detained for? Am I being detained? Am I being detained?
The legal landscape surrounding traffic stops in the United States, as illustrated by the landmark 2007 case Brendlin vs. California, is crucial for understanding citizens' rights during such encounters. According to legal precedents, a traffic stop constitutes a seizure for all occupants of the stopped vehicle. Determining whether this seizure amounts to a detention hinges on whether a reasonable person would feel free to leave or decline the officer's request. The court clarified that actual submission to the officer's authority is necessary for the encounter to be deemed a seizure. Consequently, if an individual refuses to comply with the officer's instructions and manages to evade their presence, it does not constitute a seizure unless they had already submitted to the officer's authority beforehand. Applying these principles to the case of Officer Mashburn and Mr. Barnwell, it becomes apparent that Mashburn's actions, including displaying his badge, signaling for a traffic stop, and instructing Mr. Barnwell not to leave, could reasonably lead one to believe that they are not free to depart. Given Mashburn's profession as a probation and parole officer, whether he possessed the proper paperwork for traffic stops is less essential in this case because Mr. Barnwell cooperated by pulling over. Mr. Barnwell confronts Officer Mashburn for 15 minutes, during which he asks how long the Terry stop should last, particularly in the context of a traffic stop. Although traffic stops frequently include Terry stops, they are not the same. The 2009 decision of Arizona vs. Johnson held that a traffic stop is a valid Terry stop, authorizing the detention of a vehicle and its occupants for questions about a traffic violation.
Am I being detained? Are you making a citizen's arrest? Sir, you know you pulled me over 15 minutes now. How long is the Terry stop? Can you call your supervisor? Call your supervisor, please, right now. Thank you. I don't see you making a move to call your supervisor. So you can't call on the radio your supervisor? Sir, I may leave here with a couple of tickets, but you're gonna leave with a bunch. Hey, you see that? If you're out here patrolling the highways, how fast was that car? You're an expert on speed. How fast was that car going? I don't have radar. I can't judge speed. Sir, I'm asking you again, will you call your supervisor? That's not the way the law reads, and you know what a Terry stop is. A Terry stop is 15 minutes or less. So am I free to go? Am I free to go? I don't have to go to college to get a law degree to know the law. 15 minutes, Supreme Court ruling, Terry versus the state of Ohio. All right, how about that? Where'd you get your law degree? Western Carolina University. I'm glad you have a law degree. So I have to have a law degree to know the law? No, all I want you to will you answer one question?
We'd probably both going about our ways doing their jobs. You going home and me going to do my job. You understand what I'm trying to tell you?
I understand what you're trying to say.
The only thing I was doing was stopping you, getting you pulled over so one, you calm down and quit endangering other people's lives.
I wasn't endangering nobody's lives.
Yes, sir.
We're in more danger when you got me pulled over right here than we were out here going up and down this highway.
Possibility of truth.
So I'll tell you what I'll do.
Look,
Since we're talking and being calm, will you answer one question for me, and I won't say another word to the state trooper. Am I being detained?
Never talk with you because you cannot talk to me.
Why is that not a yes or no question?
Well, you already been stopped.
But you won't say, am I free to leave then? Since you won't answer that.
I've already answered that question.
So you won't say if I'm being detained or not? Oh, I am agitated because a probation officer pulled me over for going 48 miles an hour because he was in the left lane for the last 5 miles.
In a landmark legal case in 2015, Rodriguez v. S., United States, the U.S., Supreme Court established clear guidelines regarding the duration of a traffic stop. This case emphasized that such stops, akin to Terry stops, must be brief and focus primarily on addressing the initial traffic infraction and ensuring safety. Any prolongation beyond what is necessary for these purposes is considered unconstitutional. Analyzing Officer Mashburn's case, it appears that the prolonged detention, ostensibly to wait for another officer, may have exceeded the legal limit. This raises concerns about the legality of the prolonged detention, potentially constituting an unlawful act that exceeds the allowable scope of Mr. Barnwell's detention and investigation. Therefore, in this case, the court could rule that the initial detention was unlawful, with the extension the purpose of which was for the police to arrive, an unlawful extension exceeding the limit. It is legally permissible for routine traffic stops. Officer Mashburn initiated a traffic stop on Mr. Barnwell without proper authority. This action, unjustly carried out, resulted in Mr. Barnwell's inconvenience for approximately 30 minutes until another officer arrived, resolving the situation. Mr. Barnwell, understandably aggrieved, documented the encounter and shared it on YouTube, sparking local media interest. The Department of Public Safety is investigating Officer Mashburn's behavior, and it's unclear whether Mr. Barnwell intends to sue.
And wouldn't get over.
You sit tight here, and we'll get to the bottom of it.
Here he is, good. So here's the state trooper.
You better calm down and
I
fish
am
your
gonna calm
license
down.
out and
I've
some
got my license
insurance.
out.
Hey, sir.
Yes, sir.
How are you?
I'm good.
Good, good. Hey, look,
Me either.
what we're doing right here. Okay, so, he just felt like you were aggressively coming up on him. He's a probation officer. And
I'm wound up, and you're unwinding me. I appreciate that.
Okay, so where you headed to? You headed back home?
Home to Alabama.
Okay. All right. So look, one of those things. Okay. You may have come up on him a little quick. He may have, it's one of them things. Okay. So like I said,
I'm good. I'm good now. I'm calming way down.
I don't have anything to write you for. I don't have anything like that. I'm not going to do anything. Even if I'm not going to. It's not my fault. He just feels, he just felt like you come. Let's just back it down a little bit. You're nearly to Georgia anyway. So,
that's why I say I can see it. I appreciate it.
So, all right. So,
all right.
I mean,
oh, we own a restaurant.
Restaurant. I got you. Okay. All right, sir. Well, I'm gonna let you carry on the way. Okay.
I apologize to him if he'll walk up here.
Well.
No, I'm sorry you had to come out here and deal with this stupidity.
I mean, he's wound up. I was wound up.
Yeah.
When he pulled up, he got up in my thing, and I'm like, I don't know if this guy's a police officer.
Okay. All right. Understandable.
All right. Thank you.
Be careful now.
Look at him, hands on his hips. He's mad that he couldn't get nothing.
Officer Mashburn is under fire for conducting an improper traffic stop, exceeding his authority and failing to follow proper procedures. Mr. Barnwell questioned the officer's authority, contacted 911 for assistance, and remained calm while balancing compliance with his rights. The investigation will determine if Officer Mashburn made a mistake owing to faulty information or if he purposefully broke the regulations. It has been noted that probation officials can make traffic stops in some states, and Mr. Barnwell may have been better off remaining silent until another cop arrived. The trooper who arrived later is being praised for handling the issue calmly and fairly, acknowledging that Mr. Barnwell was stopped suspiciously and seeking to calm things down without taking sides. We hope that through this video, you have gained a deeper understanding of this issue and will join us in spreading the message of fairness and transparency. Please hit the like button if you agree with us and want to further share this issue. Don't forget to hit the share button to spread this message to your friends and family. And don't forget to subscribe to not miss out on future videos from the Cops America channel.